Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about forum selection clauses and choice of law clauses in contracts. I'll have more in just a moment. When you deal with Acme Plumbing, and Acme Plumbing is in the same state that you're in, it's unlikely that you're going to see a forum selection clause or even a venue selection clause in a contract when you deal with them. But if you deal with an out-of-state entity, it is very common for big corporations and even smaller ones to insist that any action that is brought against them for breach of contract or something else be litigated on their home turf. Now, these forum selection clauses seem very benign at the outset, but here is an example of one, and pay close attention here. Any legal action or proceeding with respect to this agreement or the services provided hereunder, or for recognition and enforcement of any judgment in respect hereof, brought by the other party hereto, or its successors or assigns, must be brought and determined in the state courts of the Commonwealth of Massachusetts or the United States District Court for the District of Massachusetts, and may not be brought or determined in any other forum or jurisdiction, and each party hereto submits with regard to any action or proceeding for itself and in respect of its property, generally and unconditionally, to the sole and exclusive jurisdiction of the aforesaid courts. Now think about that. If you live in Connecticut, maybe that's not such a big deal. Or if you live in New Hampshire or Vermont, maybe it's not such a big deal. But if you live in some other place like California, that could be a huge issue. You're going to have to fly all the way across the country to litigate a claim against these folks, particularly if they breach the contract. In other words, you are literally submitting to a court halfway around the world to decide your case for you if you sign a contract that has a forum selection clause in it. Now, most of these contracts are basically boilerplate contracts that are unmodifiable. At least that's what you'll be told. But generally speaking, when somebody decides that they don't want to sign one of these contracts, sometimes the terms like a forum selection clause can be negotiated. I never recommend that you litigate a claim anywhere other than the court where you live. If you agree to a forum selection clause, you are more than likely going to be bound to it, unless you can show that you were fraudulently induced to enter into that agreement. And I mean specifically enter into the forum selection clause. You are not going to be able to break out of that clause. The same thing applies in a situation where you're asked to decide what the choice of law is. Well, the choice of law rules for contracts vary from state to state, and generally speaking, the lawyers that represent the company in Texas may very well know the laws of Texas better than a lawyer in New Jersey or Michigan. And as a result, if you sign a choice of law clause that says you agree to the law of another jurisdiction, that can create a lot of problems for you, even if ultimately you wind up trying the case in another venue. Here's an example of a choice of law clause. This agreement is to be governed by and construed in accordance with the laws of the state of New York applicable to contracts made and performed in such state, without giving effect to the conflicts of law principles thereof. Each party hereto agrees that it shall bring any action or proceeding in respect of any claim arising out of or related to this agreement, to the extent possible, in the bankruptcy court and solely in connection with claims arising under this agreement. Well, that is a pretty broad and sweeping both choice of law clause as well as a venue selection clause. And it's not a good idea to sign an agreement like this, because you are basically admitting to the jurisdiction of a court that may not even have jurisdiction over you. And so it is never a good idea to sign a choice of law clause that goes outside the state where you live, or agree to venue or jurisdiction in a court outside the state where you live. Think about this. You have to go and hire a lawyer in that state to represent you on your claim. And a lot of places like the Midwest, legal fees tend to be much more reasonable than they do on the East Coast. And as a result of that, you may wind up paying a lot more to get legal help on a problem if you agree to a forum selection clause that takes you out of the state where you live. Now, why do I say this? Well, there is a really interesting case that comes out of the Missouri Court of Appeals Eastern District, and it sort of puts forth all of the reasons why you should avoid a forum selection clause. And it's an excellent treatise on this subject. In this case, it was not a choice of law clause so much as a forum selection clause. Here's how the court described the situation. So this is a case where there are 4 counts. The first 2 counts deal with fraudulent inducement, and the second counts, 3rd and 4th counts, deal with fraudulently issued checks that were dishonored, and as a result, there is a claim under Missouri law for that. Here's how the court described the issues. Appellant raises 3 points on appeal. In their first point, appellants argue that the circuit court erred in granting respondents' motion to dismiss their fraudulent inducement claims against the individual defendants because they could not invoke the outbound forum selection clauses contained in the finance agreements which designated venue in Dallas County, Texas, in that they are neither parties to nor third-party beneficiaries of the finance agreements. In their second point, appellants argued that the circuit court erred in granting respondents' motion to dismiss with respect to their fraudulent inducement claims because the forum selection clauses in the finance agreements lack precise language requiring the litigation of those claims in Dallas County, Texas, and the resolution of those claims does not involve the interpretation of the finance agreements. In their third point, appellants argued that the circuit court erred in granting respondents' motion to dismiss their fraudulent inducement claims because enforcement of the forum selection clauses would not be fair and reasonable. So, what did the forum selection clause say in that case? Here it is. This agreement shall be governed by and construed under the laws of the state of Texas. Any lawsuit or litigation arising under, out of, in connection with, or in relation to this agreement, any amendment hereof or any breach hereof shall be brought in the courts of Dallas County, Texas, which courts shall have exclusive jurisdiction over any such lawsuit or litigation. So I was incorrect. There is a choice of law portion of this clause too. So this is a very, very broad forum selection clause. And there is a problem with it being so broad, at least as far as the appeal goes here, and we'll get into that in a minute. But here's the interesting thing. The company, Delta Plains Services LLC, signed the contract, and one of their managers, Mr. Brown, he signed it not only as a manager and officer of the corporation, but he also gave a personal guarantee under the contract. And as a result of that, the circuit court dismissed both the Delta Plains LLC and Mr. Brown from the fraudulent inducement claims, which are a tort claim. They stayed in with regard to the bad checks that they issued, but they got out of the fraudulent inducement claims. But there are 2 other people involved here, Horton and Still, and the court looked at that issue separately. Here's what the court said. We agree with appellants that Jones and Westfall control our analysis on the first point on appeal. Therefore, because Delta was clearly a signatory of each finance agreement, and by and through its managing member Brown, it may enforce the forum selection clause against appellants. In addition, because Brown was also a signatory of each finance agreement in his individual capacity as a personal guarantor, he likewise may enforce the forum selection clause against appellants. However, Horton and Still present a different case because they are clearly non-signatories of the finance agreements in any capacity. In fact, as noted above, the petition contains no allegations regarding any relationship, direct or indirect, between Delta on the one hand and Horton and Still on the other. Therefore, under Jones and Westfall, Horton and Still cannot enforce the forum selection clause against appellants because appellants simply did not agree to litigate any claims with Horton or Still in a designated forum, as they did with Delta and Brown. So the appellants here will get to go after the two parties who were really principally involved in inducing them to sign this contract in Missouri, but they won't go after the two companies. The court then goes on to discuss the second claims with regard to Delta and Mr. Brown. And it says, parties to a contract may agree in advance to submit personal jurisdiction in a given court by means of a forum selection clause. A forum selection clause is a contract that selects the venue in which a case is to be tried. An inbound forum selection clause provides for trial inside Missouri, whereas an outbound forum selection clause provides for trial outside of Missouri. In this case, it was an outbound forum selection clause that took this to Texas. So the court had to analyze whether or not the forum selection clause would apply in the case of Delta and Brown. And the appellants are saying, hey, look, it doesn't cover this. The plain language of it doesn't cover a tort action against them for fraudulent inducement. The Court of Appeals of the Eastern District was not particularly impressed with that argument. However, the existence of a forum selection clause in a contract that requires contractual disputes to be litigated in a specific forum does not require tort claims between the same parties to be litigated in that forum, absent precise language to that effect, and they cite a case called Jitterswing. So it would seem that there was nothing in there that covered tort claims. But the problem is that both Jitterswing and the other case, Riley, that the appellants cited here, doesn't precisely match up with the contours of the forum selection clause in this case. And here's what the Court of Appeals said about that. In contrast, the forum selection clause in this case governs any lawsuit or litigation arising under, out of, in connection with, or in relation to this agreement, any amendment hereof or the breach hereof. Thus, because the forum selection clause not only encompassed claims arising under the subject agreement, like it did in Jitterswing, but also included claims arising out of, in connection with, or in relation to the subject agreement, its reach is far greater than the forum selection clause in Jitterswing. Accordingly, we conclude that even if appellants' fraudulent inducement claims do not arise under the finance agreements, they certainly arise out of, are connected with, or related to the finance agreements. So for that reason, the appellants lost with regard to Delta and Mr. Brown. If they are going to try a case involving fraudulent inducement against them, they are going to have to do it in Texas. Now, on the bad check charges, they went to trial and they secured a $172,000 judgment against them. But at this point, we don't know how the case will ultimately end up because, at least with respect to with respect to Brown and Delta, that case is going to Texas. If it gets filed at all, it'll have to be filed in Texas. So that's where this winds up, and it's an interesting case because it sort of illustrates what I was talking about earlier about why you should never, particularly when you're dealing with an out-of-state entity, hand them an absolute club to use over your head in the event they decide they want to breach an agreement with you or change its terms, because in essence, they are restricting your power to enforce the agreement in the state where you live. That is never a good situation, and you want to avoid that if at all possible. So that's the situation in this case. I thought it was a very interesting teaching case. I hope that you have found something useful to take out of this. If you have any questions about forum selection clauses, whether they're inbound or outbound, choice of law clauses, inbound or outbound, you can certainly leave them in the comments down below and I will try to get you an answer. Thank you very much for watching and have a terrific day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.